What hidden loopholes exist in IHL treaties? Imagine trying to build a fence to keep everyone safe during a storm, but some parts of the fence are unclear or easy to slip through. That's similar to what happens with international humanitarian law treaties. These treaties, like the Geneva Conventions, are meant to protect civilians and regulate how wars are fought. But some tricky language and gaps can be exploited, making protections less effective. For example, many treaties have complicated wording that was often the result of political negotiations. This can lead to different countries interpreting the rules in their own way. So, what one country sees as a violation, another might see as acceptable, especially when it comes to attacking certain sites or using specific weapons. This ambiguity leaves room for parties to justify actions that should be illegal. Another loophole involves the rules about humanitarian aid. Many treaties requiring the consent of the controlling authority before aid can be delivered. This means that even if civilians are suffering and need help immediately, a party to the conflict can refuse or delay aid by claiming security concerns or accusing aid workers of being spies. This creates a window where aid can be blocked, even when lives are at risk. Exceptions to protections are also a problem. The treaties allow for certain actions if they are deemed necessary for military purposes, but these exceptions are often interpreted broadly. For instance, civilians who are directly participating in hostilities may lose their protected status, and even hospitals or schools can be targeted if they are believed to be helping the enemy. Such broad interpretations can be used to justify attacks that should be prohibited. Enforcement is another weak spot. The treaties relying on states to police themselves, but powerful countries can avoid accountability. For example, during the crisis involving the Rohingya in Myanmar, some governments refused to investigate or admit violations. Without a strong international enforcement mechanism, violations often go unpunished, which encourages further breaches. Definitions in the treaties can also be vague. Who exactly counts as a combatant or what counts as direct participation in hostilities? Because these terms are not always clear, parties can classify individuals or actions to avoid responsibility or protection. Plus, rules differ depending on whether a conflict is international or non-international, creating gaps in protection based on the type of war. Protection during sieges or evacuations also has flaws. For example, corridors meant for civilians to escape can be shelled or blocked, and parties may refuse to allow safe evacuations. The law states that forcible transfers are forbidden, but in practice, some parties still carry out forced relocations or block evacuations, especially on their own territory. Lastly, some combatants misuse humanitarian symbols or claim to be aid workers to carry out military actions. This abuse can cause civilians to lose trust in aid organizations and lead to stricter controls that make it harder for genuine humanitarian efforts to reach those in need. All these loopholes show that while the Geneva Conventions and other treaties set important rules, their effectiveness depends on clear language, honest compliance, and strong enforcement. Without these, parties to conflict can find ways around protections, often at the expense of civilians. Addressing these issues requires ongoing efforts to clarify treaty language, improve international oversight, and foster a true commitment to upholding humanitarian principles in every conflict.